attorney who can put together a memo that you can bring to your employer and say, hey, this is like what the program is, what we anticipate the cost to look like, and how we can help you. And I will also tell you that personally, whenever I encounter a student who's in this kind of, let's call it conundrum or problem, I always encourage them to say, hey, I'm more than happy to jump on a call with your employer just to explain, right? And I always tell them that as an attorney, I can't necessarily lie to them, right? Ethically speaking, I have to tell them what is the truth and how to maintain compliance. But you're right, it is a little bit of a sell. I highly recommend people to truly like look into the program first, really delve themselves deeply into the research of like what it means to qualify for the program before presenting it to your employer. You never want to just talk about it and then your one shot in explaining it goes to right? To be really, really prepared. And I will say maybe one thing that can also help for a lot of people if they're interested in the J1 Research Scholar process is think about, in the context of the company, what are you researching and what are you producing? Right? If there's something to show that it's innovative and something that can help, let's say, the general public, right? That's always a good start to be able to clarify, like, what is the project that you're going to be working on, or what is it that you're going to be researching that your scholarship is needed and your expertise is also needed.
Right. Makes sense. Yeah. So I also definitely recommend reaching out to attorney before going and just putting out in front of employer and they denying straight away that, sorry, we don't do it. Yeah, definitely a good approach to follow, Nicole. Thanks for that. And while moving with my next question, there is someone who is asking about their STEM. So I'll just read the question for you. Maybe you can answer.
Okay, yeah, sure.
Yes, I completed my master's in information systems and worked as a software developer for 2.5 years. My H-1B was picked and approved in March under consular processing. My STEM OPT expires in Jan 2026. My employer is asking 6,000 to file a change of status. Should I pay and file from the US or travel to my home country for stamping? Should I go this year or wait until my OPT ends?
So I want to kind of like mark a first red flag here. I don't know why your employer is asking you to pay for the change of status, right? Let's make it very, very clear. An H-1B cannot be paid by the employee. The legal fees and the filing fees have to be paid by the employer, guys, right? Department of Labor made that super, super clear. So I will tell you that what your employer is asking you to do is not honestly very legal. It's not really supposed to be happening. So that's the first thing that I would say, right? So let's assume for argument's sake that this didn't happen, right? That this was just a normal employer who's interested in working with you, right? So if you want to change what was previously a consular approved let's say H-1B, right? You're trying to change it into a change of status that will require an amendment. So it is a fresh filing. It is technically a re-argument in a way, but you can essentially just use information from the previous filing. And then you can essentially ask to change status domestically here in the US. But when you're asking me, hey, should I travel home to my home country for stamping instead? Technically, you could do that to activate the H-1B so long as that job that got you that H-1B is still relevant. Because if not, if you're trying to change to a different employer, right, you will need to get that new approval notice before going for consular process. Another element that I want you to consider is that travel right now is a little dicey, right? I think there's a lot of people having conversations about, is it worth it to exit the country? Should I really be risking it for a visa appointment? I think everybody's looking at the news about how from September 2nd onwards, interview waivers are gone. They're all gone, right? What are we going to do? Except in like limited circumstances, of course, right? So in that kind of perspective, I always tell people, listen, the most defensible position and really the safest position is to try to avoid unnecessary travel, right? As powerful as the H-1B can be, it doesn't stop administrative processing. Oh, I can't find the document in this database. I'm going to issue you a 221G. I'm going to put you in admin processing, and you'll be stuck outside of the country for anywhere from 1 month to 12 months, right? So the reality is that it's always better to avoid unnecessary travel. Try to keep it clean and simple. Domestically, there's a lot of things that we can defend, we can argue, we can rebut. So I would say, hey, if your employer is willing to pay the costs, do a change of employer or an amendment in order to get that activation here in the United States.
Okay. That's good. And the same person is asking if at all they want to change from software to electrical engineering. So how will that affect their H-1B?
Well, so long as your qualifications allow you to argue that you qualify for both kinds of roles, then I don't necessarily see an issue, right? Somebody who has an electrical engineering degree, for example, could be a software developer, could also be a hardware developer, could also be in quality assurance, could also be someone who's a product manager, right? All of those things actually fall under many different SOC codes. It's just all about, do your qualifications match with the job that is being offered? And is the job that is being offered required at least a bachelor's degree to fulfill? Do not be a simple computer programmer. That SOC code is a dangerous SOC code, right? But the nice thing about STEM, and I would say generally for engineering degrees, is that there's mass appeal, right? It applies in so many different occupations. So really take into consideration your qualifications against the job that's being offered.
Right. Good. Thanks for clarifying that, Nico. And also one important question I want to ask, right? So since we are talking about OPT, STEM, and three chances of H-1B lottery, as soon as a person enters the US on OPT, so is there a way that they can start looking forward for a different visa than H-1B and start planning for it, like a O-1 visa or EB to NAW? So what is the guidance that you can provide around those kind of visas?
Oh, absolutely. So let's start first with the O-1 visa, right? Yeah. I always tell people the earlier that you think about it, the better. Even if you're like a freshman in college, right? You just got into the university of your dreams. You come to the United States and you start studying in your freshman year, your first set of classes, right? You'd be surprised the wealth of network connections and opportunities that you get while you're at school. Right? So for example, connecting with your professors, like professors are scholars, right? Graduate research assistants also are scholars. By virtue of being scholars, they're usually connected to judging databases for your peer review. They're also members of editorial boards for scholarly publications, right? Those connections are extremely rewarding because they can get you onto those projects that would get you those publications, for example. They could also get you into those databases that allow you to start doing peer review. Maybe not while you're in school, but it's more so that you develop that relationship. Once you're graduated and you're in your OPT or STEM OPT, that's when you start really proliferating the evidence that you need and developing the evidence, utilizing and leveraging those relationships to get into those right places, right? A lot of attorneys, and even sometimes myself, we tell people like, hey, scholastic achievements are not really good achievements for an application, right? So we'll say like your scholarship unfortunately doesn't really mean much. But I really want to say that that's a very nuanced answer. The true answer is that there's actually a lot that you can do while you're in school. And it's those relationship development that really can help with an O1. Those recommendation letters from those esteemed experts are going to be extremely powerful. Other things that I would tell people, especially when they first come to the US outside of relationship building, is really thinking about how you can become very public facing while you're in school. Right. And it's all about really thought leadership and less so, I'm just talking to the general public whenever I can. It's like, how do I get into these conferences? How can I be engaging with wider members of people within my industry? Right. It's not really, again, the networking. It's really more so start talking about the things that you are interested in, start talking about the career path that you are on. Right. And really start going to these conferences and maybe start doing smaller presentations. I've met some really wonderful young AI engineers, and they're getting into NOR IPS, they're getting into QCon and all this kind of stuff. And it's crazy to me because of how like innovative the industry is. It's really the youngest of people who really know the coolest stuff. So really delve deeply into those interests and try to like sell it out there.
Right. And while we spoke about the education side of it, if at all someone is having a business idea and they want to set up a company and they are looking for an O1 visa, is it the same path that they need to take, or they need to follow a different approach in terms of getting there?
I think for people who are more interested in entrepreneurship, like I will tell you again, if you're here as a student, because usually most people start that way, right? You come in as a it's a bachelor's degree or a master's degree, right? When you come in, it's the scholastic programs that give you the connections to accelerator programs, incubator programs, and maybe like those VCs or younger VCs that are out there. And it's those opportunities that can really grow into the foundation of a solid O1 for a tech entrepreneur, or even just generally somebody who's interested in business, right? I will tell you that one of the things to consider is that you have to be really careful about setting up businesses here in the United States when you're on F1. Right? The thing is that the government decides it based on how active and how passive you are in the business. It's not a good idea to be the only owner making business decisions while you're here on your F1. But just remember, when you graduate, at the end of your, let's say, schooling period, you get OPT. OPT gives you the flexibility to open your business. STEM OPT, not so much, right? But that 1 year can be powerful enough for you to focus on building your company, getting some operational legs into it, and then also separately really focusing on, I would say for entrepreneurs, publicity. Publicity is a big one, right? Because when you own your own business, you can talk about your own business, talk about it everywhere, right? And also you'd be surprised at editorial content that a lot of these companies or these publications are really striving for. If truly your business idea is amazing, somebody will want to write about it and somebody will want to talk about it. It's also a great litmus test for you as an entrepreneur to see if your idea is really that good, right? If you get your name out there, that's already one of the criteria of the many criteria that people can work for an O1.
Exactly, yeah. So thanks for adding that, Nicole. And there are a couple of more questions on the chat, so I'll read them for you. I am on STEM and my consular H1 was approved. If I want to work for another employer, I need to convert to normal H1 and then transfer to new employer, or I can directly transfer to the other employer, or I can work with STEM for some more days with new employer.
You should be able to immediately file a change of, a new employment application for the H-1B for the new employer here in the United States. You don't necessarily have to go STEM to activating your consular H1 and then back to the United States for the new H-1B, or filing an amendment to go to that old employer and then filing for the new employer. So long as you've been counted against Cap, right? You can file for the new employer. Now, I will tell you that a lot of the times what would determine the strategy is actually the circumstances of your case, right? What can you prove in terms of managing to show that you've maintained your status so far? What are the things that you can show to prove why the decision was made to maintain your OPT instead, right? There are strategies that are involved that we would need to discuss to make sure that this is the best path for you. But generally speaking, if you've been counted against Cap, there's not really a requirement for you to go to your, I guess I'm using your terminology here, right? To convert to the normal H1 and then get to the new employer.
Right, got it. And also, there is one common issue that I hear from a lot of folks, Nicole, is that they'll be working with employer A and their H1B will be picked up with them, and they will do in a consular approval process. And they get a job with a different employer and they need to switch the H1B and they're really stuck in between. And what is the approach that they can follow in order to switch the H1B to a different employer?
So I will tell you, it's a little bit of a gray area. Like, I know why, the reason why a lot of people ask that question, because the gray area is this, right? Did you truly activate the H-1B and fulfill the intention behind that Cap H-1B, right? The trickiest point for a lot of people is when you get that new role in like August, right? The start date for the only H-1B is in, or this consular approved H-1B is in October. In those kinds of scenarios, I actually do recommend getting it activated first before you change employers, right? Because it puts you in the most conservative light in the sense that, yeah, you did fulfill that intention, right? I would wait until October and then change to the new employer. However, right, there are reasonable legal arguments that I've seen. And I will tell you that it's kind of unclear if under the current administration that they would treat it the same. That under Biden, it was basically interpreted as, no, you were counted against Cap, it's fine, we'll file the application, right? The other thing that I would also say is this might be a little bit of a roundabout way to do it, and it depends on how much the new employer is willing to try this. File for concurrent employment, right? You're allowed to have another role, right? You're allowed to have another job, right? If you can reasonably argue that you're going to be taking on a second job and you need to start it sooner rather than later, then file for concurrent employment instead.
Okay. I mean, so again, the question comes in, what is the risk in future if I do a concurrent employment? That is also a question, but yeah, as you said, it's a gray area for sure.
Yeah, I mean, for concurrent employment though, I've never really had a strong issue, right?
Okay. Okay.
I don't think I've gotten that much pushback. I think it's really just explaining the circumstances of why a concurrent employment was needed, right? I'll tell you some of the craziest cases that I've done. I had like a person who was working for like a big financial institution, and they were like a financial analyst, right? They approached me and they said, "Hey, I need to do concurrent employment, but I want to be a singer." And I was like, "Wait," I was like, "Wait a second, like, I have a question here," right? So usually singers can't qualify for an H-1B, but we made a really solid argument related to becoming like a music director. That was a very nuanced application, but I was a little bit concerned because the government can see, like, wait a second, you're telling me that you qualify for being a financial analyst, but you also qualify to be a music director.
Yeah.
If you make the argument and you have the right advocate in your corner, if there's a will, there's a way, right? To the most extent that we can do, right?
Right. Got it. And there is one more question. I am into biotech. I'm currently in my OPT, soon entering STEM OPT period. So I still have two chances at H1B, but looking at other alternatives in the worst case scenario, what would be the best option to stay in status if not considering a PhD?
Okay, so you have two more chances, and you're on your STEM OPT period, and you're in biotech.
Biotech, yeah.
Okay, so we talked about this a little bit before, but the J1 Research Scholar Program, heavily recommend people take a look at that. But separately, two other things, right? You have the O1 as well, right? You have a 2-year timeline, assuming that you have 2 more chances on the H1B, right? A 2-year timeline is a solid period of time for you to start investing your resources into opportunities that can really level up your ability to apply for an O1. Just to take one step back, for an O1 application, especially an O1A, since you're in biotech, you need to meet 3 requirements out of a possible 7 that's like listed out there. I think it's like 7 or 8, right? The reality is that some of the things that you should really be doing are investing time into judging opportunities. Are there biotech competitions? Maybe it's kind of crazy like how much technology has evolved, right? Are there like healthcare tech like competitions that you could be judging for? Are there peer review opportunities that you really should be looking into within your field, right? Alternatively, you should really be considering scholarly articles, but not in the traditional sense. I think a lot of people focus on scholarly articles as if it has to just be research papers published in high impact scholarly journals. But when you take a look at the guidances, they actually split the guidance in half. They have the academic way to meet scholarly articles, and then you have the non-academic way of meeting scholarly articles. The government is aware that not every single person is in academia, right? And not every single person is a traditional scholar. So long as you have published what is essentially a well-researched article, and it is published in a publication, like a trade publication, whose target demographic is sizable enough and is specifically for other industry professionals within your field to view and to read, the government can accept that as a scholarly article. It's just in the non-academic sense, right? I guess the best way to explain it is if you're an economist or a financial analyst, you wrote a really great article that's like, the United States should invest in Vietnam more than China for manufacturing, and here's why, right? You wrote up the whole article and you referenced all of these world reports, these charts, and these data that other people have collected, and you consolidated and you made an argument. If that was published in The Economist, there is a reasonable argument for a scholarly publication here, right? The weird thing is that if you publish it in the New York Times, as much as that's way more prestigious, the government can come back and say that that's a mainstream publication for the general public and not for industry professionals.
Okay. But if you want more information, you can definitely book a consultation call with the attorney, and so they can guide you and help you with more information as well.
Of course.
And there are 2 more questions, but before taking those questions, I have one more thing to ask, Nicole, right? So there are really people who have like good experience in their home country and they're coming to US, working here for like few years and looking for other options like EB2, NAW is one that I heard about, right? So what is the right time for them, or what is the approach they need to follow in order to get into the path of obtaining an EB2 and NAW, right? So
yeah. So when it comes to EB2 and IW, it's all about 2 items that I'd get to anyone for a checklist, right? Number 1 is identifying an endeavor or identifying something that you want to do in the United States that is of national interest to the US. The earlier that you identify this plan, honestly, the better. Even if you already have, let's say you have experience, You're coming to the United States, whether it's like you mentioned here for studying or here to work for the first time, and you build yourself up towards a self-sponsored green card. Trust me, identifying the endeavor first is what I recommend to everybody. An advice in terms of how to identify an endeavor, I really tell people to go on the news and identify a problem statement that the government is dealing with, right? And I would say, let's say the reason why US and China have a weird relationship is because the US relies on China for cobalt. Why do we rely on China for cobalt? Because of batteries. All of our batteries need cobalt, right? So suddenly you're thinking to yourself, well, if the US has issues with cobalt, what if I had the ability to design a battery that doesn't rely on cobalt, right? Or I could create alternatives to cobalt, right? So I tell people, look at the news, start there, and think about what can you do to resolve a problem that the government is encountering, right? That's number one. Then number two, especially when you're here in the US already or trying to approach the US, now you got to think about how you can prove to the government that your plan, your vision is even possible, right? Who are the connections that you need to have? What are the labs that you need to be involved with? Who do you need to be reaching out to so that they can give you the support that you need in order to get whatever this dream and this project done, right? Could it be in the vehicle in the form of a role? Maybe you're coming to the United States and you're going to be working in your first job at a company like Moderna, right? And you're going to be researching like a new novel drug, right? That could be one way to prove that you're well positioned. But if you're an entrepreneur, it's about the connections that you make to show like, oh, you know, I'm going to be working or collaborating or consulting with these companies that will drive the solutions that the government is looking for, right?
Okay.
That's like my suggestion for EB2 and IWs, but it's the earlier the better for sure.
Okay. Thank you so much for that. And there are two questions. I'll take one. Is the process for getting H-2B petition for an employer difficult and lengthy?
Yes. I'm just going to say yes, right? It's going to say yes because the H-2B requires a pretty extensive Department of Labor process. I think a lot of people think that, oh, because not a lot of people talk about H-2Bs, that it might be easier to acquire. The reality is that it's actually a very cumbersome process for companies, and it does have a longer lead time than a lot of people consider. This is not something that you apply in a month. This is not something that you apply in like 2 months. It's something that an employer really needs to plan for over a period of maybe 6 months to a year, right? Now, if your employer is willing, that is a conversation to be had. But I also will tell people that you have to remember that the H-2B requires you to have an argument, needs to be seasonal, needs to be temporary, needs to be an urgent need, right? And you need to be able to prove that that exists. If anything, some people should be considering maybe the H3 program instead. The H3 is like a leveled up version of the J1. Now, hear me out though. The H3 is a very rare visa. I think in the past, it was mainly used by like Disney because they had the proof that was needed. But the H3 program is something that I have done for people in the past. And just to tell everyone what it is, it's a trainee program, but you have to prove that the training that you're trying to do here in the United States is just not available in your home country, right? If you can prove that it's not available in your home country, then there is an argument for training. So to give you an example, if I'm working for a dairy manufacturer, right? And let's say I'm French, right? I need to come to the United States to work at a dairy farm in Wisconsin to make Wisconsin cheddar because I need to learn how to make Wisconsin cheddar.
Right. Yeah.
I cannot learn to make American cheddar in France. So that is the argument that I would make in that kind of circumstance, right? So that's how I would think about it. And the reason why Disney was able to do that is that there is no Disney in Norway. There is no Disney in India. There is no Disneyland in Indonesia, right? So something to contemplate.
They got it. Interesting. So I'm hearing the H-2B and H-3 for the first time, and interesting to know about those two visas as well. Yeah. So, I mean, I think we are almost on the time. We'll just take two last questions before we wrap up. The one question is, I work for municipality and only option my HR says is H-1B.
You work for so I would say government-related rules are so tricky, right? Because they do have like, I wouldn't say it's like regulations, is that they have really strong internal policies and internal rules when it comes to who they sponsor, how they sponsor, right? But here's the one thing that I have learned is that sometimes the only reason why they think that way is because they had no idea that there were other options. right? Education is a strong problem when it comes to government workers or to a lot of like organizations in the US, right? If most of the coworkers that you have are American, and you might be like one of two foreign nationals, chances are the company just doesn't know. It's not just part of their vocabulary. It's not just part of their conversation, right? So if you work for a municipality and they keep saying your only option is H-1B, you might need to come back to them and present them the options. But again, and I've said this in an earlier question, right? Don't show up with just ideas. You need to show up with a proposal, like a formal proposal.
Okay. Right. Yeah. Thank you. Last question for today, Nicole. On a slightly separate note, are you familiar with the Conrad 30 waiver program for J1 physicians, and whether J1 can only be converted to H1B, or if it can also be converted to these alternatives like EB1, EB2?
Okay, so let's start first with, am I familiar with Conrad 30? The answer is yes. It's a popular program, let's call it, for removing the 212E or the foreign residency requirement for people who are foreign medical graduates studying in the United States. So ECFMG.
Interesting.
Right?
Okay,
now, the thing is that with the Conrad 30 waiver program, it can be a little bit competitive. But I do recommend people who qualify for it to do it, to remove that requirement, right? That being said, it isn't necessarily true that J1s can only be converted to H1Bs. J1s can, in many circumstances, be converted to O1s. However, they must go for consular processing. The reason is because some funky rules, right? The O1 allows you to postpone the physical residency requirement, the 2-year home residency requirement. But the only way to postpone it is to go home and then postpone it through the consular processing, right?
Okay.
But in the long run, you still have to fulfill that 2-year foreign residency requirement in some form or way, unless you get a waiver for it. So when you're talking about converting into alternatives like the EB1 or the EB2, they're going to check if you did live at home and work at home for at least 2 years before coming back to the United States, unless you get a waiver.
Okay. Yeah, I think so. That's it for today, Nicole. And thank you so much for joining the session and sharing insights about the H1B alternatives. And I got to know new things about H2B visa, H3 visa, and this Concord 30. Thank you so much for explaining all these things. And for everyone, thank you so much for joining. And if at all you want to talk to any attorney from Manifest Law, or even you want to reach out to Nicole, you can book the consultation using the link that is pasted in the chat. And you can always feel free to reach out to me on my Instagram channel and also the Manifest Law as well.
Right, for sure. Thank you so much for having me, Shriram. The reality is that this Q&A function, I try my best to answer as many people's questions as best as I can, right? But if you really want a deep dive into what can be done for you, what can be done for your family, your friends, right? Whoever really needs that support, right? You need to really come to us and start talking to us. Let me see your resume. Let me see your background. Let me see your circumstances. We're known for those creative solutions. We're a tech-forward, tech-driven, data-driven, research-driven firm, right? And I think that's what really drives the fact that we're very solutions-oriented, and we do know some of these crazy visa options that are out there. Okay. All right. So thanks, everyone.
Yeah. Thank you so much, everyone. Thanks, Nicole. Bye-bye.
All right.